A Grammy award-winning rapper's fate lies on the outcome of his high-profile murder-for-hire case. But before the case is brought in front of a jury, his attorney is sounding the alarm, claiming his rights have been violated because of a smart tool. This is Inside the Crime presented by Law&Crime. I'm Elizabeth Millner. Federal prosecutors say Lil Durk is the mastermind of a sinister plot that ended in murder. While he should be prepping for the fight of his life, his defense attorneys say that the last 4 months he's been in isolation, and prison officials are giving conflicting reasons on why. It's October 17, 2024. We're in South Florida, near Miami International Airport, when suddenly federal agents swarmed to arrest rapper Durk Banks, known better to his fans as Lil Durk. Federal agents got worried when multiple flights were booked under his name, one to Dubai, one to Switzerland, and one to Italy, because they believed he might have been trying to make a run for it. But he never made it to boarding. When news came down of his arrest, it was shocking. His face and his mugshot were everywhere. The headlines reading, a Grammy award-winning rapper accused of being the mastermind and orchestrator of a murder-for-hire plot to take out a rival. There's so many layers to this case that some already know. But to scratch the surface of this case, here's some quick background. Back in 2020, Durk's best friend and collaborator, King Von, was gunned down outside of an Atlanta, Georgia nightclub. On that night, King Von and rapper Quando Rondo got into a fight. Although Quando wasn't accused of killing King Von, Quando's friend was accused of shooting at him, with one of the bullets fatally striking King Von. And if you believe the prosecution's version of events, Lil Durk wanted revenge, but he wanted to take it out on Quando Rondo. By August of 2022, the alleged plan was already in motion. Durk's alleged associates learned Quando was staying at an LA hotel. They flew from Chicago to San Diego, then drove to LA using money allegedly provided by Durk. Federal prosecutors even alleging Durk had one specific instruction: don't book no flights under no names involved with me. The killers were provided with hotel rooms, ski masks, luxury sedans, and weapons. The men, not including Durk, followed Quando, who was with his cousin, to an LA gas station. Then bullets flew. Prosecutors say while the intended target wasn't killed, his cousin was. Afterwards, the suspects went to an In-N-Out to discuss payment before flying home to Chicago. Durk, through his attorney, has denied he was this criminal mastermind who ordered out a hit on Quando. By November 14th of 2024, he pleaded not guilty to his federal charges, which include conspiracy, use of interstate facilities to commit murder for hire resulting in death, using, carrying, and discharging firearms in a machine gun, plus possession of such firearms in furtherance of a crime of violence. Now, while Durk wasn't accused of pulling the trigger, he's still facing a lot of years in prison if he's convicted. While federal prosecutors took the death penalty off the table, Durk and his co-defendants could face a statutory max sentence of life in prison. Again, only if convicted. The case was first slated for trial last January. Then it got pushed and pushed and pushed again. However, as I'm recording this, the trial is on the calendar set to begin in April. Durk's attorneys have filed a series of motions since he's been behind bars. Of course, they filed a motion to dismiss the indictment as the defense cited false and/or misleading grand jury evidence. That was denied. The defense filed a motion for his detention to be reconsidered. That was also denied. In the latest court filing, his defense requested a status hearing because Lil Durk's been in the SHU for 4.5 months. This is what his attorney Christy O'Connor wrote in the latest filing. Since August 29, 2025, Mr. Banks has been confined to the segregated housing unit at the Metropolitan Detention Center. In the SHU, Mr. Banks is confined to a very small jail cell, just large enough for a single bed, a toilet, and a sink for 23 hours a day. He does not have access to commissary. He is permitted one phone call a month and no in-person social visits. The original cause of his SHU placement was an allegation that he was in possession of an unauthorized Apple Watch. Since August 29, 2025, Mr. Banks has not received the process that is prescribed by law where an inmate is accused of an infraction. Mr. Banks' defense team has received conflicting explanations for his extended SHU detention without process. For example, in October, an attorney for MDC told us that Mr. Banks' high-profile/celebrity status is not the cause of his SHU detention. Then on December 22nd, the warden represented to us that Mr. Banks' presence in the general population poses a threat to the security and orderly running of the institution due to the high-profile nature of Mr. Banks' pending criminal case and possible violation of BOP's disciplinary program. This is despite Mr. Banks' 11-month presence in the general population prior to August 29th, without any incident whatsoever caused by his celebrity status or the high-profile nature of his case. The filing goes on to say, in response to our inquiries, the government has provided us with an internally inconsistent explanation for Mr. Banks' extended SHU detention. On one hand, the government tells us Mr. Banks' continued placement in the SHU is not based on the FBI's investigation or the USO's charging decision. safeguarding the Apple Watch. On the other hand, the government tells us that the BOP is waiting to institute disciplinary proceedings related to the Apple Watches based on our charging decision. Both of these statements cannot be true. Either the process to which Mr. Banks is entitled has been delayed and his stay extended due to the government's ongoing investigation, or it has not. Durk's attorney cited an article from the American Public Health Association called The Psychological Distress in Solitary Confinement, Symptoms, Severity, and Prevalence in the United States. The scientific study reveals psychological effects of inmates after being in the SHU. Symptoms including clinically significant symptoms of depression, anxiety, or guilt, disproportionately high rates of serious mental illness and self-harming behavior, and social isolation, loss of identity, and sensory hypersensitivity. So citing these examples, Durk's defense is concerned about him being in solitary confinement because the longer he's in there, it could be violating his Eighth Amendment right, the one that prohibits cruel and unusual punishment. A hearing was set on the matter for January 7th. Criminal defense attorney Safa Robinson Ferreira joins us on Inside the Crime now. And Safa, 4.5 months is a long time for solitary confinement. What's your reaction to what Lil Durk's defense attorneys are alleging?
His attorneys, what they're alleging is essentially that he's been in there for a significant amount of time. And unfortunately, as a result of that, there's a diminished capacity in terms of his mental health and things like that, because we know, traditionally speaking, the more that somebody is isolated, and particularly in solitary confinement, it can have a significant impact on their mental health. It can trigger depression, anxiety, all sorts of things. And so I think his team is doing the right thing by highlighting this and making the court aware of this. The basis for them bringing this to the court's attention, I think, is some discrepancy with what the jail, or I think it's MDC, has communicated, which was either this is as a result of an Apple Watch violation or his status as a celebrity in the institution. And his attorneys have gotten both explanations as to why he's been in solitary so long. And it's not very clear as to how long he's expected to be there and if the appropriate administrative proceedings have taken place so that he can ultimately be released from that status.
And does any part of you think that this is punishment because of his celebrity status, or do you really think that it's possibly the Apple Watch that has him in the SHU?
I think if this was only about the Apple Watch, that certainly could have put him in the SHU. It would likely be considered contraband. Mm-hmm. But at the end of the day, how long is he expected to remain there? Sometimes we see 30 days. Sometimes there are other mechanisms that the prison institutions do use in order to mitigate or have some sort of culpability and responsibility when an individual does violate their code of conduct and things of that nature. So I think 4 months, if it is about an Apple Watch, is absolutely extreme. I think the other end of this is he is a celebrity, and not only that, but he's a unique individual in the sense that he's alleged to be tied to gang relation, or he's alleged to be gang related. And so when you see individuals or clients like that in institutions, they're a little bit more selective with where they are placed. And sometimes they have to keep them away from other individuals. So it's not clear the actual reason as to why, but we know his attorneys have highlighted the things that at least have been told to them. And now this is the accountability factor for the Bureau of Prisons or for MDC to actually say and explain why Mr. Durk or Lil Durk has ultimately been held this long.
And we're learning that Durk's trial is supposed to begin in April. There's always that possibility it could be pushed back again, but we'll see. But it's supposed to begin in April. But how difficult is it for a client to prep for a trial if they are in the SHU for such a long period of time? His defense attorney is also citing, to your point during our first question, about how much of a psychological damage that can really happen to inmates who are in solitary confinement, especially for a prolonged period of time.
It's extremely difficult. And usually, as defense attorneys, we always like and we love when we can prepare our cases with our clients out of custody, when they're able to come to our offices and we can watch footage together, speak to investigators together, our own investigators, I should say. It always makes it easier for us to defend the case that way. It can be a little difficult logistically to take in certain things into the facility. The prisons ultimately have their own rules as to what can come in, what can come out. Sometimes I might bring in a computer, what you can leave, what you can copy, what you can print. It just makes it so tedious and a bit more difficult in addressing these things with our client, as opposed to if they were out of custody. And certainly him being in the SHU gives an added layer to that, because we've got to also deal with his unique situation of being in the SHU and what that has done to him mentally. And what we also know, and it's very clear, is that a person has to have the ability to participate in their defense, and they have to be mentally competent to do that. And if there's a diminished capacity or diminished competency, then that might be something that we have to explore later.
And then he really isn't in the fight for his life at this point because he's facing what could be a statutory max sentence of life in prison, even though he's not accused of pulling the trigger. And we'll talk about that more in a second. But I imagine as the defense is prepping for the trial, there's a lot of evidence that needs to be sifted through, gone through. The feds have been building this case for years, so I'm sure it's going to take a while to go through all the calls, the text message, videos, if that's in evidence. But what do you make of what could be an overwhelming amount of evidence spread across multiple defendants and not just Lil Durk? How difficult is that as a criminal defense attorney?
Sometimes it can be difficult, but I think, and this is always the approach that I take, it's my job to represent my client. And so I like to create a timeline and parse things apart that are specific and applicable to my client. We have to first look at the facts or the details of the case, and then place everyone's involvement where it belongs. Who is expected to be a witness, who could ultimately testify against the client, and things of that nature, and what we can expect that testimony to be. So we've got to sift through all of that. Another thing is we hire our own and have our own investigators to do some of the work with and for us, because, you know, the government's always going to put forth what they believe proves their case beyond a reasonable doubt. But it's also our responsibility to do our own investigation and to gather evidence in favor of our client. And we will do that. And so it can be a lot. It can be very monotonous, tedious, and voluminous when it comes to dealing with these discovery issues, but it's not anything that a good set of attorneys can't handle. It's not anything that a great set of defense attorneys can accomplish in the hopes of also getting a not guilty verdict at trial.
And as we talk about this case, I know some people have their own thoughts on Durk's alleged involvement. He's not accused of pulling the trigger, just pulling the strings, according to prosecutors. But in your opinion, Safa, do you think a jury will actually see it that way?
It's going to depend on what the evidence is and as it rolls in. And so while there may be a ton of evidence and it's voluminous, the key here is that these pieces of evidence have to come in, or this evidence that they have has to come in appropriately at a trial. Just because there is something that is a piece of evidence, for example, that exists in discovery, doesn't mean that it will come in at a trial. A proper foundation has to be laid with the proper witnesses. Ultimately, life happens, things happen. Sometimes the witnesses are not available by the time trial comes around. And those things we often will use to our benefit if that is the case. And so with respect to getting all of these things accomplished and completed, there's a lot that goes into it, but I'm sure that Mr. Durk's team is ultimately going to be well equipped to handle that moving forward.
And prosecutors say that they have multiple witnesses already prepared to testify, and I'm sure the most important witnesses that they'll probably put on the stand are the analysts who go through the texts, the calls, etc. But for those who are allegedly involved in this plot, do you see any of them taking the stand or maybe turning on each other, possibly even turning on Lil Durk?
That's always a possibility, and that's always something that we prepare for, and preparing for the worst. You know, there are a number of co-defendants involved in this case, and that's always something that we have to look out for, is the government trying to please certain people out and get cooperation from them on the eve of trial or as the case prepares to commit to trial. And so that would not be surprising. I'm sure that those conversations probably have been had between the prosecution and some of the defense attorneys, if the clients are willing to cooperate. As attorneys, we have to discuss that with our clients if it comes up, even if we don't think it's a good idea, and even if they don't want to do that. I think, again, with this case and the nature of it, can I see these actual co-defendants testifying? Likely not, but we'll see. It's going to be their choice.
And it'll be interesting because, again, the stakes are very, very high in this case. And prosecutors have even previously pushed for an anonymous jury. Do you think that's necessary in a case like this? Prosecutors have also previously said that Durk's supporters have already made threats toward the judge and the prosecution.
I don't think it's necessary, but I understand why that is the case. When you do have certain elements where it's involving a murder charges or witness tampering, and it's a high stakes case, to your point, where he could likely spend the rest of his life in prison. Sometimes people are willing to go the extra mile, whether it's him because of his celebrity or his supporters or other individuals that are involved. And so in the abundance of caution, I can understand why they would move to have an anonymous jury. I don't think that it's completely necessary, but I can understand certainly why they would consider that.
And Safo, there are plenty of times we've seen indictments, we've seen what's laid out in paper and writing, and then once we get to trial, it just feels like a completely different case. It doesn't feel as strong as what was laid out in an indictment. But do you think that the prosecution's evidence is strong enough to convict by everything that we know right now?
I'm not quite sure. And the reason I say that is because it seems that this case, there's no direct evidence, there's no smoking gun, but this seems to be more circumstantial. This is going to be pieced together with analytics by certain analysts who are going to be looking at, are they wire transfers, purchasing of plane tickets, things like that are more technical in nature that they're going to use to tie in and show that all of these things were done at Lil Durk's direction. But again, if the government can have the appropriate witnesses and line things up so it's in a digestible manner for the jury to hear and understand, and if it's enough to actually truly convict. An indictment is a piece of paper, it's an accusatory, it's not a conviction. So the government still has that heavy burden of proving each and every element of those offenses beyond a reasonable doubt.
And it'll be interesting to see, again, because the trial is supposed to begin in just a few short months. But I'm curious, do you think it'll be difficult to even seat a jury in this case? Durk is a well-known rapper. Obviously, this case might be hard to seat a jury in this case if it were to happen in Chicago. But since this is a federal case, it's happening in Los Angeles, do you think it'll be difficult for a jury to be seated?
I think it's still going to be difficult to seat a jury on this case because of the length of time that this trial might take. That's always a factor. People don't like sitting on juries, and the people that do like sitting on juries, usually we try to get rid of them. And not only that, but you do have individuals who may know information about this case that could have some sort of bias. They could think that Mr. Durk is a rapper and gang related, and they might be afraid to sit on this panel. There's a lot of other factors and questions that will be asked during voir dire where the attorneys and the judge will be able to sift out the jurors. But I do think that it's going to take quite a bit of time to get a jury on this case. Maybe not as long as the Diddy case or the Diddy trial, but I do think it's going to take some time to get there.
Yeah, and it'll be interesting. Unfortunately, I wish that we could have cameras up in that courtroom, but again, it's a federal case, so unfortunately cameras are not allowed. But I would love to be a fly on that wall or be a reporter in that courtroom just to get a piece of the action. Safa Robinson, I want to thank you so much for joining me here today. I really appreciate your time.
Thanks, Elizabeth. Good seeing you.
Online records as of this recording show Durk Banks is still behind bars in the Los Angeles Metropolitan Detention Center. According to reports, his high-profile federal trial is scheduled for April. Thanks for tuning into this episode of Inside the Crime. I'm Elizabeth Millner.